The Constitution, dead or alive? The late Supreme Court Justice Antonin Scalia was known for four things: constitutionalism, love of people, humor, and mischievousness. And all four were on display when he used to tell visiting school children that the Constitution is dead, dead, dead. This was shocking to the children, who were used to the reassuring progressive message that the Constitution is living. I mean, living is better than dead, right? Well, it depends on what you mean by living and dead. When progressives say the Constitution is living, they mean that it changes to suit the needs of the times as determined by progressive Supreme Court justices. But that requires that the Constitution be dead in terms of its original meaning. Imagine a cheating husband who considers his marriage vows to be living, to suit the needs of the moment. His wife, on the other hand, considers the marriage vows to be dead in light of her husband's infidelity. And for the vows to become living from the wife's perspective and the original meaning of the vows, they must become dead from the husband's perspective. This is exactly what Scalia was driving home to the school children. Interpreting the Constitution according to its original meaning is the only way it can have living effect today as the supreme law of the land. If the Constitution is living in the progressive sense, it becomes a sock puppet. It doesn't speak for itself. It's dead. Like Scalia, the Founding Fathers considered the Constitution to have fixed meaning in order to enshrine timeless principles of good government in a fallen world. This is confirmed by the fact that they included an amendment procedure, and further, that they made it very difficult. It requires a 2/3 supermajority of Congress or of state conventions to even propose an amendment, followed by a 3/4 supermajority of the states to ratify it. But you see, no amendment procedure is needed at all if the Constitution is living in the progressive sense. The progressive justices simply locate new meaning in the Constitution. The court has done that in a number of different cases, but probably the most famous is the 1973 case of Roe versus Wade, when the court decided to just locate a right to abortion in the Constitution. At that moment, the Constitution was living in the progressive sense, but it was dead, dead, dead in terms of its original meaning and intent, which was to create a government to protect people's God-given rights, beginning with the right that is foundational to all others, the right to life. But the significance of a progressive court with a living Constitution goes far beyond any individual case, no matter how significant that case may be. For you see, the end result is that we are no longer living under the form of government the Constitution was adopted to create. You see, if the President or Congress engages in an unconstitutional act, the Supreme Court can strike it down. But answer this question: who will strike down an unconstitutional act by the court itself? You see, Supreme Court justices are appointed for life. So the only check on the court's power is the Constitution itself. But if the court can change the Constitution's meaning, there's no check on the court's power. The court has become a star chamber, answerable to none. That's why progressives go to such lengths, either to get new progressive justices on the court, stacking it with progressive justices, or to block constitutionalist justices from ever getting on the court. To progressives, you see, they're not fighting over a Supreme Court justice. They're fighting over a star chamber lord, a progressive star chamber lord.